one of the biggest results that we've had. It involved a pre-existing condition to the lumbar spine. The verdict was over $117 million. It was an extraordinary result. It was the largest verdict in New York State in a personal injury case. And it was the largest pedestrian verdict for that year in the whole United States. He was healthy, he was fit, he was working in a full-time job, he was active. This was a guy in his early 30s who was doing great. There was no issue, but it was there beneath the surface. And what nobody knew until he got hit by the car is that he was more susceptible and more vulnerable to having a big problem if he ever got struck in the low back. And that's exactly what happened to him. He got struck in the low back by this car. It took those previously asymptomatic, quiet pars defects in his lower back and made them symptomatic. And it also caused one of the vertebrae at that same level to slip, a condition known as spondylolisthesis. And it was the combination of those two things, the slippage of the vertebrae and the activation of the pars defects, that started to cause him so many problems in his low back. He had just started off in his career. He was a hardworking guy, and all he wanted was to get back to work. He didn't want to have a case. He wanted to put the case behind him, and with each stage of the treatment, it was about, is this going to work? And is this going to be the thing that's going to get me better and get me back to work? He assumed, I'm going to get better. This is not something that's going to sideline me for any length of time. I'm going to be able to overcome this. When people get hurt, they think that they're going to get better, and they have this optimism that they're going to get their lives back, and this is going to be a temporary thing, and it's not going to sideline them for some substantial period of time, or God forbid, forever. Each time he had a surgery, there was the expectation, this is the last surgery. This is going to do the trick, and he's going to be able to get back to work. But he didn't. He was out of work a lot. He was losing weight. He was in pain all the time. From the beginning, the insurance company looked at this and they said, this is a pre-existing condition. There's no traumatic findings here. There's no traumatic injury. Whatever's here on the MRI, whatever the doctors are finding, it all predated. It was all there before. This was a low-speed incident that happened in a parking garage. It didn't cause him any significant harm. His pre-existing condition was really the culprit, that the incident didn't activate or make worse the pre-existing condition that he had, that he could go back to work, that he wasn't disabled. They just never accepted the fundamental aspects of the case. That's what they do in most cases, whether it's rejecting that the accident was their client's fault and trying to deny responsibility, or to blame the plaintiff, to blame our client, or to reject the injuries and say the injuries are not as bad as they say, or if they have problems, it's from something from before. That's what they always do. They look for something in the person's past medical history, whether it's a past injury, whether it's a natural condition, a congenital condition, or whether it's from age. We have a lot of clients in their 50s and 60s and 70s, and of course they have a lot of natural deterioration throughout their body from age. That's natural. Everybody over 50 has that. So the insurance company takes advantage of that. We have a concept in the law known as the eggshell plaintiff. And what that means is that if someone has a past medical history with their spine, if they've got deterioration in their spine from age, if they have an old accident from years before involving their neck or their back, or they've got some natural or congenital condition in their spine, any of those things can be aggravated or exacerbated in an accident. And part of that concept in the law is the idea that someone with a pre-existing condition, someone with a past medical history with respect to their spine, is actually more vulnerable and more susceptible to getting hurt in an accident, more likely to have a bad outcome, more likely to not respond to treatment, more likely to need surgery than a person with a normal spine who's healthy, because they're more vulnerable. Because when the incident happens, they already have a predisposition to being hurt, to developing symptoms, to having a bad outcome. We prepare for trial from day one. Everything that we're doing in the litigation from the very beginning is with an eye toward trial. And as the litigation progresses and the full scope of the case becomes clear, we are adding experts, we're adding elements to the case as we go. And so the answer is we were preparing this case for trial for years before the actual trial came up. And in the months before trial, it was a furious effort of nonstop preparation to get all the witnesses ready, to get the testimony ready, to have all the evidence in line. It was an enormous amount of work, and we devoted tremendous resources to being ready to have success in the courtroom. We look at the person's past medical history. We will get the records of their medical treatment from the years before the incident. If there's a prior injury or prior accident in their past, we'll get those records too. If they have a natural condition or congenital condition in their spine that has gone on for years, existed for a long time, we'll investigate that. Then we'll look at the trauma. Is this the kind of incident that could cause an injury to the neck or worsen a condition in the low back? We will look at what happened right after the trauma. Were there immediate complaints of pain? Did the person go to the hospital, go to the doctor right afterward? Is it documented that a condition that may have been asymptomatic or mildly symptomatic all of a sudden was bumped into becoming symptomatic or made worse? We look at everything that happened before and everything afterward, and we put all those pieces of the puzzle together. No case is perfect. There were some bad facts in the case for us, meaning things that we were worried about, we knew that the defense was going to exploit. And when we prepared for him to testify, we said you have to address all of this stuff, and you have to address it honestly. The defense, rather than acknowledge at least some of his suffering, decided to go on the attack, and they went after him. And they said, this guy's an exaggerator. He's a liar. He's a malingerer. One of the most important and pivotal parts of the trial, and I think probably the most emotional part, was when his wife testified. And I wasn't sure how it was going to go, but I had this sense and this expectation that she was going to do great. And so in the beginning of the case and in the beginning of his injury, it was also the beginning of their relationship. They met through acquaintances, and it was a long-distance relationship to start. And then he got hurt just when the relationship was 3 or 4 months old. She had her own life. She actually put herself through law school during the years of the case and was a lawyer practicing by the time the case went to trial. She had this sense, okay, this guy who I really like, who I just met, he's gotten hurt, and it seems to be a big thing because he's missing work and he's going to the doctor. But she, like him, had this expectation that he was going to get better. And I think there's a lot of women who at some point along the way would have left him, especially after this first surgery failed, especially after he had to lose his job, the job that he had when she met him and that he had when the accident happened, when he couldn't get back to work after losing that first job. But she didn't leave him. They actually got married. They got married during the life of the case. They had this wedding that was not really even a wedding because he was injured throughout that day and barely able to get through that day. They had a honeymoon planned. They were supposed to go to Europe. And again, there was this expectation, in a couple months, I'm going to feel better with this new treatment. I'm going to turn the corner. And of course, they're going to plan a honeymoon because you're hopeful and you're getting married. And also, I think he had this feeling, I don't want to lose her. If I lose her, I'm going to have nothing. I have to get better, not just for myself, but for her. And so he not only had, I think, the optimism and the hope that he was going to get better, but I know inside he was scared that if I don't get better soon, she's not going to stay with me. But she did stay with him. And that was a whole story that we told at trial because there was a wedding video and the defense and discovery asked for the wedding video. And normally that's something that, could be damaging to the plaintiff, and the plaintiff is worried about because maybe the wedding video is going to show him smiling and having fun, and maybe even dancing, and he's not going to look like he's injured. This wedding video actually helped us because the story of that wedding day was not different from a lot of the days and events that they tried to do during the life of his injury. He had to lay up in his hotel room for the whole day, resting and taking medication before he went downstairs for the ceremony and for the wedding itself. And while everybody was dancing around them and celebrating, you could see in this video that he was barely moving. And they were not downstairs with everybody for that long. The reality was that he needed to go upstairs and rest. A big part of this case was the disability and the lost wages. And there was a big claim for lost wages because he was a young guy and he was a professional and he had his whole career ahead of him. And we had to make sure that the lost wage case, with all of its experts and all of its proof, was bulletproof. But what was unique about the wage claim in this case, in as much as he was a professional and he was highly educated and had all of this training, he had just started his working life. He had just started his career when he got hurt. So there wasn't an earnings history over a period of years. This was not like someone in their mid-40s or 50s who had been working as a professional for a decade. And you could go back and look at the various years before the accident and say, okay, he was earning this, and then he was earning this, and then he was earning this. And we see the progression of income over years. He had only been working a couple of years, but he had gotten through all his schooling and he had gotten through all his training. So there was a reasonable sort of belief and expectation that he had his whole career ahead of him. So what we needed to do was find experts in his field, not just an economist who could analyze the numbers in the tax returns and the like, but we needed experts in his field who could tell us what a professional like him was likely to have earned over a lifetime, what those progressions would have meant to him as he became more experienced, as he had more successes in his career. We had to forecast a whole career without a lot of information about the beginning of his career because it had just started. And so we found one of the best experts in his field, and we found the best data. And so we had a real concrete factual analysis of what his career would have looked like, the whole arc of it, and what his successes would have looked like. And to give the jury latitude and to make it credible, we laid out several different scenarios where there was one where he sort of was moderately successful, there was another where he was more successful, and then there was even a third where he was like a superstar. So the jury could decide after they heard his testimony and took the measure of the man, what his earnings would have been like had he not been injured, what his career and career successes would have been like had he not been hurt. And ultimately the jury decided that this was a guy who they not only liked and believed, but who they thought would have been a very successful guy in his field. And they went to the very top end of what we presented as the different wage options. There are a lot of lawyers who think juries are unpredictable, juries get it wrong. That has not been my experience. Over 22 years of practicing, over decades of doing trials, it has been my experience that almost always juries get it right. Juries get to the right decision in a case. Juries want to do the right thing. They're smart and they're thoughtful. Their hearts are in the right place. And even when I've lost cases, and every lawyer loses cases, I've understood the reasons why the jury got to the result that they did. And so I'm of the view that most of the time, juries get it right, and they find the right result, and they see the truth in the case, and they understand what is legit and what is not legit between the claims and the defenses in the case. And so the way we approach presenting in front of a jury, the way we approach trying cases, is to trust the jury. When we have a case that is a mix of good and bad, and most cases, like in life, are a mix of good and bad, we put it all out there for the jury in an honest way. We give them the good and the bad. We trust that they're going to understand and put things in context. We trust that they're going to see the big picture. We trust that they're going to see the common sense in the situation. We trust that if the bad facts have an explanation or can be put in a context that is understandable, the jury's going to figure it out. We don't try and sell the jury. We don't try and spin the jury. We don't try and bob and weave and play games with the jury. Because in our experience, number one, it doesn't work. And number two, it doesn't come from the place and the perspective of trusting the jury. It was a long case. And by the end of it, all of us were exhausted. But we also had this sense that it had gone well. You know, we were hopeful that we were going to get a good result, but we didn't know. You never know. And the jury, I think, started deliberating on a Wednesday, and it went into a Thursday. And there were delays because the jury wanted to hear portions of the testimony read back, and there were some delays with getting that testimony. The jury didn't come in until a Friday afternoon. My client was there in the courthouse, his wife was there. It was the end of a grueling month, and we were all exhausted, and it was a tremendous physical struggle for him to be in the courthouse for the whole trial. And we were getting near the end of the day, and there's a sort of a strict time when the court has to close in the afternoon. And the judge actually kept the jury later than the courtroom normally stays open. So the jury came in with their verdict close to 5 o'clock on a Friday evening. And when it came in, it was a tremendous victory for us. The verdict was over $117 million. It was an extraordinary result. It ended up being the largest verdict in New York State for that year of any personal injury case in the state. The verdict was the largest pedestrian accident jury verdict in the United States for that year. When you have a verdict like this, there's a lot of things that go into it. But what were the factors that led to a verdict in excess of $117 million? It was the genuineness and the truthfulness and the compelling nature of our client's story, how he came across and how his wife came across and the story that they had to tell, the way the defense attacked them without good cause. All of that came together to produce this tremendous result.